Chair, the floor is yours.
Yes, yes, I think it's 10:32, so we should get started with the session. Well, the session it's on the blind spots of international law, and clearly there is a bit of an interrelation here between classic international law, national legal systems, and other forms of normativity which are emerging in the current global environment. So I think it's going to be very interesting. And especially for comparative lawyers, this is interesting because comparative lawyers don't go that much into this kind of gray area between comparative law and international law. Nor international lawyers do that. Nobody does that except few discerning researchers and scholars researching this new thing. So I'm very, very happy that we are here. It's the few of us, but few is good. I trust we will have a great discussion. So unless you have reasons to do differently, I would follow the schedule. So will be Giovanni Barbieri first, Marta Bono second, Sandy third, in this order. And then the format here, due to the technical issues connected with Zoom, is that we have the three presentations and then we have a final discussion. I assume it's very few of us. We can have some flexibility, but I would stick to the format unless there is a reason to make a comment on the spot, to interject with anyone presenting. So I would invite Giovanni Barbieri first to present his paper. Giovanni Barbieri is a researcher at Tampere, Finland, and also an invited or external researcher at the Catholic University of Milan. He is very much involved in global studies, globalization, regionalization, Belt and Road Initiative, and many other interesting issues. His presentation today is Jus in Bello as the new Jus ad Bellum, a possible pathology in international public law. So it sounds already very interesting. Giovanni, you have the floor. 20 minutes more or less, and then we'll see.
Okay, I think I will take less than 20 minutes. By the way, thank you for inviting me to this interesting conference. First of all, I must outline that I'm not a comparative lawyer. I'm a political scientist, so I'm finding myself in a sort of moral subjection, talking of these issues within comparative lawyers. For the sake of clearness, I'm no longer a researcher at Tampere University. I'm a research fellow at the Università Cattolica del Sacro Cuore and in the Center of Economic Research and Analysis in the same university. The subject that I want to analyze with you today is a slippery subject because it tends to be more political than a legal issue. That is the international practice that during last decades developed mainly by Western states to interfere in the domestic affairs of sovereign states for humanitarian reasons. This is the very difference between the jus ad bellum and the jus in bello, because as we all know, the jus ad bellum refers to the conditions under which states may resort to war or the use of armed force in general. And the prohibition against the use of force among states and the exceptions to it, like self-defense and United Nations authorization for the use of force, was set out in the United Nations Charter of 1945. And these are the core, it's the core ingredients of jus ad bellum. While instead, jus in bello regulates the conduct of parties engaged in an armed conflict, and international humanitarian law is synonymous with jus in bello, and it seeks to minimize suffering in armed conflicts, notably by protecting and assisting all victims of armed conflict to the greatest extent possible. And it applies irrespectively of the involved parties as well as their motivations. And traditionally, these two things are independent from each other in the sense that once a state decides to wage war against another state, it do so upon the norms of jus ad bellum, and only once the wars have started, jus in bello applies. But during last decades, we witnessed an evolutionary path in the interstate relations, and in particular in armed interstate relations. And considering this specificity, we can draw upon some facts. These facts are that every political order gives birth to a specific legal order, and this attains particular at domestic level. At the international level, this relationship becomes more complicated because the boundaries of international political order are not so clear when we are to define an international political order. For instance, nowadays, we live in an international liberal political order. But this political order is completely separated by another emerging political order coming from the East. So we can say that the current international liberal political order is a Western international political order that comes with a specific international legal order that is built upon Western legal principles. And this implies that these legal principles, these international legal principles, are not shared, or at least not all of these legal principles are shared. Another fact is that the fields of international warfare and humanitarian armored intervention show well the dynamic relation between these two levels, the political order and the international legal order. A conviction of mine, a belief of mine, is that the nexus between political order and legal order is a matter of power relations. This is nearly a Gramscian view of the global power relations. And looking back at history may help in explaining this evolutionary path in the practice of international warfare and international humanitarian intervention. We can consider that after the Second World War, that is between 1945 and 1990, the international system was governed by a shared set of rules framed within the multilateral framework of the United Nations. And concerning humanitarian intervention, we have the well-known Resolution 36103 of 1991 of the United Nations, and the International Court of Justice judgment of June 27, 1986, that banned humanitarian intervention, and specifically concerning the case of Nicaragua versus the United States. The situation slightly evolved after the collapse of the USSR in the post-1991 world, where the United States emerged as the world policeman, so charged with duties of preserving international security and preserving international stability. And to this extent, we saw this specific attitude of the United States during the course of the First Gulf War, when the US emerged, as I said previously, as the world policeman, and acted upon the mandate of the United Nations Security Council. It was the resolution 688 of 1991, but they went well beyond the United Nations Security Council mandate by invading Iraq specifically. Another case occurred during the 90s, the last decade of the 20th century, was the ex-Yugoslavia war, where the North Atlantic Treaty Organization produced a new, we can say a new norm with the out-of-area operation to preserve international security and stability, going well beyond the original mandate of the Charter of the of the North Atlantic Treaty Organization. And this is to say that during the last decade of the 20th century, the nexus between jus ad bello and jus in bello in conducting international relations started to change, signaling a sort of suffering of the previously shared set and framework of international norms that regulated the interstate relationship. And this resulted in what some organizational scientists and as well as political scientists called organized hypocrisy. The first organizational scientist that developed this concept was Brunson in 1989. And according to Brunson, organized hypocrisy occurs when institutional norms fail to agree with the requirements for actions, and organization will often try to create two sets of structures and processes, one for each type of norm. And these sets should not interfere with one another, but should be separated or decoupled. Turning this definition in political terms, in political science terms, it means that rulers and not states, and not even international systems, make choices about policies, rules, and institutions. Because rulers want to stay in power, and being in power, they want to promote the security, prosperity, and values of their constituents. Now, this meant clearly a radical transformation in the global power relations, and a radical transformation in the way how international norms and the corpus of jus ad bellum and jus in bellum was understood. And this turned out particularly evident during the first decade of the 21st century, when the United States started their international campaign of the global war on terror. And we all remember Colin Powell shaking the famous proof of the weapon of mass destruction in Iraq that actually didn't exist. But that was the landmark of new way of intervening within the international system with armed force that is objectively problematic under the previously shared set of norms regulating international warfare. In my forthcoming paper, my focus is on a specific aspect of this issue of the juxtaposition between jus ad bellum and jus in bellum. That is the principle of the doctrine of the responsibility to protect. The doctrine of the responsibility to protect, in my view, shows well this dichotomy between two standards of international norms, because responsibility to protect was adopted by heads of state and government at the World Summit in 2005 at the United Nations General Assembly. And it is a principle which seeks to ensure that the international community never again fails to act in the face of genocide and other gross forms of human rights abuse. And here we can see the first important evolution in the relationship between the set of norms regulating the use of armed force and the set of norms that regulates the preservation of life and safeness of civilians in international conflicts. Because the responsibility to protect developed what we can call perhaps an emerging norm, and the emerging customary norm, that is the international subjectivity of population. But to date, population does not retain international subject. It's not an international subject. States are international subjects of law, but population is not. Although that responsibility to protect consider population a subject of international law. And although it is referred to an emerging norm, it is not a binding legal obligation committing the international community, but it's merely a political instrument. The responsibility to protect is built upon three pillars. The responsibility of each state in face of international community, the responsibility of the international community to support a particular state in exercising its responsibility to protect its people, and in cases where a state fails in its duty, the responsibility of the international community to take diplomatic, humanitarian action or other means to stop this violation. While initially it was non-violent, these additional measures may be extended to armed or unarmed coercive means, as authorized under Chapter 7 of the United Charter. And here we have some problems concerning the responsibility to protect. It is a political tool. It is definitely a political tool because it's not a legal standard. Does not set a legal standard. It does not substitute yet the corpus of jus ad bellum in determining the legal conditions under which a military campaign shall be conducted. It assumes population, as I said previously, as a subject of international law. It can be exploited for political purposes. Let's think about the Western intervention in Libya, and let's think about the non-intervention in Yemen, for instance. Or let's think to the Western political pressure on Syria and the lack of political pressure for the case of Myanmar. So responsibility to protect and humanitarian intervention in these cases are driven by political concerns and perhaps by economic interests. Concluding this short brainstorming about the relationship between the two sets of norms, we can say that the relation between the international practice of recursing to humanitarian intervention to preserve international stability and international security is a debated and controversial issue. And because it comes with an high confusion among legal standards and political concerns and interests. Moreover, there is an high deformity of behaviors of the international community and in states among similar circumstances. And this leads us, or at least leads me to ask three answers. First of all is, can international humanitarian law concerns bypass the traditional and binding legal framework set by the United Nations Charter that is based on the ban on invasion, aggression, and use of force? The second question is, given the current high interdependency between humanitarian intervention and economic and political interests, shall international organizations like the United Nations take action towards the adoption of verification mechanisms to prevent political abuses, including, for instance, foreign interferences igniting domestic clashes, like it happened in Syria, for instance? Is there any international legal background supporting humanitarian intervention in justification of regime change needs? Because regime change is international practice, not based upon international law. So in sum, these are my thoughts about the issue, and I'd love to further discuss with you after the other panelists will give their presentation.
Okay. Thank you, Giovanni, for this quite interesting set of observations, remarks, questions, especially the final three ones. We will certainly discuss them. And we move on with Marta Bono. Marta is a PhD candidate at the University of Palermo in international relations at the local faculty of political science. She's involved in research related to BRICS countries and especially to arbitration amongst those countries. The presentation she will deliver is The Dark Side of the BRICS, the lack of a legal definition. Marta, you have the floor.
Thank you very much. So I'm gonna try to share my desk. So it says that the organizer has disabled the sharing. So if you please allow me.
Can you do it, Ignazio, or I'll do it?
Maybe you should Maybe should I also have a PowerPoint, so maybe you should do it also to all or to the presenter.
Ignazio, you are unmuted. You should.
You should all be enabled now to present. Try.
Yes,
Please try
it
to
works.
share. Okay.
So, as mentioned, my paper and my presentation is going to be about the dark side of the BRICS, and namely the lack of a legal definition. So, in order to address the research question, I'm going to give you first an overview of the BRICS and therefore a little historical background, the main objectives pursued by this group and the main areas of cooperation. Then we will attempt to define the BRICS using a public international law perspective, and we'll try to understand the critical aspects of this kind of analysis. Then we will see what are the propositions already advanced by legal scholars in the field to define the BRICS, and then attempt to give a definition. Finally, I'm going to give you some concluding remarks on the topic. So, the BRICS was actually born as an acronym. It was first coined by Jim O'Neill, chief economist of the Goldman Sachs, in 2001. And he was the first who brought forward the idea of BRICS, stating that China, Russia, India, and Brazil, the four emerging markets with promising economic development, would be four most powerful economic entities of the world in 2050. Now, so far, we may say that this forecast proved to be right. After 2019, at least, the BRICS contributed to the 23% of the world gross domestic products. So back to 2001, we may say that the BRICS representatives saw a potential beyond such an acronym and turned this label coined by O'Neill into a social and political reality. So they made their first appearance in the international arena in 2009, when they held their very first summit in Yekaterinburg, Russia. And since then, these countries have been meeting regularly once a year, alternating themselves in the host of the summit. Now, a very important moment in the history of the BRICS is the enlargement of the cooperation to include also South Africa, because we have, first of all, a stressed-in uppercase S to indicate South Africa. And this moment looks as a way for the group to acquire a very political dimension. So not only it is an economic grouping, but it starts to acquire a very political dimension. The objectives pursued by the BRICS have been clear from the very beginning. They have stated at the very summit, and this is something that continues to be present in the declarations, that they wanted to advance the reform of the global financial institutions, Bretton Woods institutions, particularly the IMF, the World Bank, and the WTO, as to reflect the changes occurred in the global economy. As we were mentioning before, this is understandable, considering that these financial institutions were all established after the Second World War, and they have been dominated by the US and the European countries, while the economies of these emerging countries have increased exponentially in the last decades. And therefore, they are now asking for a more adequate and democratic representation within these institutions. More in general, they also ask for the reform of the international monetary system in order for it to be more diversified and predictable. They also aim at promoting peace, security, prosperity, the development of the multipolarity, which is also a value for the BRICS, in an interconnected and globalized world. So also the areas of cooperation among the BRICS that have been increasing in the last decades, from the very trade and financial fields, we now have a wide range of matters for the cooperation that goes from trade and finance to innovation, health, culture, sport, outer space. once we have such an overview in mind, we can try to understand, so what is the BRICS using a public international law perspective. So this represents a dark side of the BRICS, considering that in order to give a definition, this is not an easy task, because none of the traditional international laws categories is appropriate to define the BRICS. So in order to start our discussion on the definition, we may start about thinking what the BRICS is not. The BRICS definitely is no longer just a series of summits. It has a very particular structure, and it is more organized than that. And yet it is not qualifiable as an international organization, because it has no constitutive treaty, nor an independent secretariat, headquarters, and or permanent staff. Moreover, for the intra-BRICS cooperation, we may say there is also the use of less binding, even non-binding international law tools, such as memorandum of understandings. So from a very public law perspective, we cannot qualify it as an organization properly. We have started the discussion by stating that the BRICS primarily gathered because they had an economic dimension in common. However, we cannot even qualify the BRICS as an economic integration organization, because an economic organization entails the transfer of sovereign competence on economic matters by the member states to the organization, and this does not occur in the BRICS. And I would say it would be rather difficult to make this real, considering also the intervention that the state has in the economies of some of these countries, if we think about China or Russia. Not to mention the fact that, as we have said, economy is at the moment just one of the main areas of cooperation among the BRICS. The BRICS themselves do not make things any easier. They have never really attempted to define themselves from a legal perspective. They have defined the way they understand the BRICS by stating that the BRICS is a platform for dialogue and cooperation in 2012, but this is a very loose definition, and it does not pretty much imply legal foundations. And so subsequently, they have stated in their main declaration that they aim at progressively developing BRICS into a full-fledged mechanism of current and long-term coordination on a wide range of key issues of the world economy and politics. However, no mention is given to the legal form that such a coordination mechanism should have. And they never really attempted to define themselves from a legal perspective any further than that. Assume this is something that is voluntarily made by the BRICS. It's like they don't want to be pretty much bound to this grouping, to this kind of a platform. And this is understandable considering the approach used by the BRICS to the grouping itself. They have privileged a very flexible club model. And this is understandable considering that the BRICS is a constitutionally non-homogeneous group characterized by enormous differences among its member states in terms of economic structure, political and social background, legal setups, culture, tradition. So in order to converge and to draw back all the tensions that still are in place within the BRICS, they had to assure that this group would have had flexibility of both intent and instruments used in order to fix shared aims. So unlike formal institutions and I would say also traditional ways of integration, there is no attempt to negotiate in order to impose binding rules or codes of conduct, nor there is any follow-up mechanism for the implementation of common policies. That is because even though the BRICS shared aims it is not necessary for them to use the same tools to achieve those aims. Every state will then implement the most suitable governmental policy, but it does not mean they will have to use the same policies. However, so even though we have such a very flexible approach, very informal approach, on the other side, this may be regarded as a dark side as well, if you want. The BRICS has shown institutionalizing tendencies, especially in the financial field. So we've got the creation of the New Development Bank and a contingent reserve agreement in 2014. But also there was an attempt to establish a virtual secretariat, actually a BRICS website that would have served as a virtual secretariat. But so far, this project seems to having been abandoned. So considering all we have described, considering that we don't have an official definition then of the BRICS, it's pretty much up to those who study the BRICS to attempt to give an agreeable definition. And therefore, several definitions have already been proposed. So as a mixture of several formations often used to change global regulation, we have said this is one of the main objectives pursued by the BRICS. It has been defined as a coalition, convenience coalition or association, which is generally framed as a temporary alliance or partnering of groups in order to achieve a common purpose or to engage in a joint activity. And this purpose is to confer legitimacy to the individual states' pursuit of multipolarity and share global responsibilities. The BRICS has also been defined as an informal forum because its members have an explicitly shared expectation about its purpose and participate in regular meetings. And as such, it resembles a G-group model of collective action, such as the G20. But in this sense, the BRICS does not qualify as an actor with legal personality. And also, if we want, in the BRICS perspectives, not always all the BRICS countries have the same expectation about the group. And this sometimes hinders the way that they behave in the external dimension. It has been defined also as a legal network or a soft structure capable of producing legal flows of policy transfer and as such an alternative to the hard rule of the European regional structure. This definition is particularly important because this shows, first of all, that the BRICS is capable of producing soft law. That even though it isn't a typical source of international law, they still may say that they do that. However, this definition is, I believe, more capable of describing the internal dimension of the BRICS, so the internal coordination among them, so the links that they are able to create, but it is not too much capable of indicating and describing the external dimension of the BRICS, the position they have in the international law. Some other definitions have been proposed as a cross-continental pressure group, a platform for the pursuit of principles of the world order, or simply as an informal club. So as we can see, there is no a single and agreed definition. And in order to give my contribution, I'm going to show you how I believe the BRICS may be defined. This is in consideration of the fact that the BRICS may represent an immiscible model for the future. So maybe the cooperation of the future is more an informal kind of cooperation, as also we can see in the international relations with the presence of many G model of collective actions. So we may define the BRICS as an international quasi-organization. So describe it in this way, the reform-oriented character of the BRICS and its informal association character, its function as a dialogue forum, which is actually the way the BRICS understands itself, as well as its institutionalizing tendencies in the form of the NDB and the CRA, and yet define it as a quasi-organization, indicating that it lacks of the traditional elements that may properly qualify it as an international organization, as the presence of a constitutive treaty. In this way, the non-binding and very flexible character of the group can be preserved as well. So in order to conclude, what we have just described so far leaves us with a very loose institutional and organizational framework of the cooperation, especially if compared with existing cooperation activities, and still lacks of a unified, single, and well-agreed legal definition. At this point, the BRICS may reconsider whether it wants to keep this network character or opt for legalizing tendencies. So in order to have a greater impact on the global governance, this point should have a little more discussion, but we don't have time right now. Even though the route towards becoming an organization seems unlikely, because this would require a greater obligation, a greater precision and delegation in rulemaking. And this would also entail an abandoning of the winning flexible architecture that the BRICS has given to itself. Or on the other side, also the public international law should adopt and recognize also, so to incorporate into the international organizations category, also this more flexible and less binding international quasi-organizations, because they still engage and contribute in a sort of way to the international law. So in the same way, the public international law was able to incorporate and to look as the subjects of international law, not only states and international organizations, but also non-state entities, considering the impact that they have in the international law. It may happen the same in order to incorporate the international quasi-organizations. What it is sure is that we cannot ignore the uniqueness of the BRICS phenomenon, and for sure, further research is necessary in order to have a realistic and complete view of it, especially from the legal perspective, and in order to fully understand this phenomenon that is undeniably characterized by light and darkness. Thank you very much.
Very good. Thank you very much, Marta. It was very interesting and certainly will inspire some debate. I already have at least one comment or question for you to be asked later on. Now it comes to Sandy Kedar. Actually, it should be Kamar Mishir Kesad and Sandy Kedar together. Sandy is with us. Kamar.
Actually, Kamar is also going to join us.
Ah, that's good. That's fantastic. So I'm going to introduce Sandy. Sandy is a longtime friend of Juris Diversitas, a legal geographer, as he puts it, and he's teaching at the University of Haifa, law and society, legal history, legal geography, but all rooted in the studies of the use of land and property law. Sandy starts with the land to develop his research discourse, which is very, very diverse, very, very non-mainstream. And I leave it to him to introduce Kamar, because I'm not quite sure whether she will appear or she'll not, or she will appear later on. So Sandy, the floor is yours. The paper is Power, Law, and Place in the Shadow of the Occupation, a legal geographical examination of the transformation of the Susia area, Shafayata, 1967 to 1998 in the occupied territories. Sandy,
Kamar is with us actually.
Yeah, she is. Okay, so thank you very much. I will say a few words about Kamar Mishriki Assad. She's a PhD candidate working with me. I'm her supervisor. She has degrees in law and she speaks 3 languages, including Arabic as her mother tongue. And she also has been very active in issues that have to do with the occupied territories. She was the funding and director of the legal department of organization called Rabbis for Human Rights. And since 2016, she is a founder and co-director of Hakel, Jews and Arabs in Defense of Human Rights. And most of her work is in the occupied territories. Hi, Kamal. So I will also share, I will do the presentation, but I would say that it's part of a joint project, joint article that we wrote, and it's going to be published. And Kamar is the lead author also. So this is just to just a moment. Okay. So I hope you see. Do you see the presentation? Yeah. Okay. So I will first, and please give me a 5. I can speak forever. So just give me a 5 minute ahead of when you think that I overstated my time. So I'm going to work and to talk first about, I would say a few words about the project. This work is part of a larger project that is funded by the Israeli Science Foundation. And it's a very ambitious project which tries to understand and to map the making of what I call the land regime in the occupied territories, in the occupied Palestinian territories. And we work as a research group with some doctoral students, some postdoctoral students, trying to understand the interaction between law and the geography in the occupied territories. So this is the major project. And I will say a few words about what I mean by the land regime in the occupied territories, then explain a few words about, very shortly, about our scholarly or the paradigm that we're working with, legal geography, settler colonialism, and the legal system in the occupied territories. I would just say since we're also doing here a comparative law, and we are in a conference on comparative law, that some of the scholars some of the students or postdocs that are working with me are also doing comparative law, for example, between the laws in Jordan and in the occupied territories. And we work also on a part of my work, working of the paradigm of comparing the places that are under the heritage of the British Empire and the British colonial regime. So some of my other work I compare with, for example, with India and Pakistan and other places. But here in this presentation, we focus mainly on the occupied territories. And after that, we'll get to our case study. So the occupied land, the occupied land and the land regime in the occupied territories, of course, the land, anybody who knows a bit of the situation that's going on in the occupied territories and the history, understand that land stands at the epicenter of the Israeli-Palestinian conflict. Land territory is very deep. But very strangely, practically no property scholars have engaged in a comprehensive analysis of the land regime in the occupied territories. There are many reasons. We can expand on that on the land in the discussion. There are people working on international law and on the issue, but very few people working actually on the land law, the actual setting of the land law, that only part of it is international law. And when I talk about land regime, I talk about a set of ideas, principles, norms, laws, institutions, decision-making processes and practices that regulate land or spatial relationship, determine land allocation, use, possession, dispossession, and ownership and control, and interrelate with a socio-political regime. As I said, the land law research on the occupied territory is lacking. So political, historical, religious, symbolic dimensions of this conflict are important. But as I say, I believe, and we believe, when I say I, it's, as I said, Kamar is the lead author of this article. We believe that space, place, and the laws shaping the land regime really stands at the core of this conflict, and very few people have researched the land situation. So since I work also, we work on geography, just to give you, I mean, this is the area, whoever is not familiar, and when we're talking now, I mean, we're talking about the West Bank, that it is this region, and more specifically, our case study is in the southern part of the occupied territories, what is here the Susia region. When we look at it, and now I move to the paradigms we're working with, I would say that despite its enormous potential as a framework to examine this legal and territorial conflict, as I said, practically no scholars had adopted, not only no property law scholars, but also nobody really adopted the legal geography approach to study these issues. And I would say, I will not get now into legal geography, but I will, whoever is interested, I co-edited in 2014 a book with Nicholas Blumley, David Delaney, Eros Braverman, Nicholas Blumley, and David Delaney, which offer an overview of what is legal geography. And recently, I wrote with Ahmad Amara and Oren Iftachel a book which examines the land dispute between the Israeli Bedouins and Israel, which also uses a paradigm of, among others, the legal geography. So when I'm talking about legal geography, I'm really talking about the relationship, the co-constitution of law and space. And just to explain what I'm meaning by that, I give you example of Jerusalem. You know, we hear about Jerusalem all the day and the conflict, and whoever is following the news, now the extreme right racist Ben Gvir, a member of the parliament, wants to walk through the Nablus Gate in East Jerusalem, and the last violence in the occupied between Israel and Gaza happened, among others, or many, because of Jews entered a dispute in Jerusalem, and I mean, but what is Jerusalem? And that's a major question. When I talk to my colleague or friends and ask them, what are you? And Israel said, we'll never compromise about Jerusalem. Okay, so what is Jerusalem? And Jerusalem, according to my understanding, is a legal creation. It's a imagined place created by law. In 1967, after the war, Israel annexed the Jordanian Jerusalem and additional many municipalities, and established what we call the whole and unified Jerusalem. And you can see here, I'm sorry, it's in Hebrew, but there are very different places that had no connection to each other. Villages, refugee camps, Jordanian Jerusalem. And what they did is they drew a legal line on the map by legislating a basic law called a Basic Law of Jerusalem. Now, this now became this unification, this imagined line on the map that became part of the law influence the location of settlements and neighborhood in the next area, the route of the separation barrier, the legal status of Palestinian living in Jerusalem, and transformed separate area that they have no any kind of urban connection to each other into a new consensual urban entity, consensual within the Jews, that never existed before. And now Israel is willing, it will never compromise on Jerusalem. And I really ask people, do you know, let's talk about Jerusalem. I mean, what's the connection of even this tiny place here, which is the red thing, which is the old city. That's all, and all this is Jerusalem. Okay, so just there is no connection, but it created a reality. So just to give you how law and geography influence or define itself. Now, a few words about the law, and I will be very short. When we talk about the law in the occupied territories, it's extremely complex, and it's based on a series of layers, starting with mostly with the Ottoman land law, the British Mandate law, the Jordanian law, the Israeli law, the law of the military commander, international law, customary law of some groups, for example, Bedouins living in the region. So it's, and in the article, we offer an overview of the different laws. And in the article, we also analyze, it's part of a series of articles, and this article analyzes the formal legal means of overtaking Palestinian land and transferring them to Jews. And in another article that we finished writing and we're now sending soon, we also analyze the informal ways that are becoming formal. For example, ways that outposts are built, illegal also through Israeli legal perspective, or the ways that settlers are overtaking private Palestinian land and moving the Palestinian using, for example, dogs to scare or physical violence. And so this is part of another article. But in this article, we review the major means, which are declaration. What Israel does is it declares land as being state land. And according to Israeli interpretation, state land can be used for whatever reason they want, including establishing settlements, expropriation of land, and allocation of this land to Jews. So this is the general background. Now we move to Susia. So in Susia, which I will show in the next slide, we examined the relationship between the application and laws and transformation of space in the occupied territories in a specific yet representative region, Susia in Shafa, and it spans over 9,000 metric dunams, and it stands now between the Jewish settlement of Susia and an illegal outpost called Mitzpeh Yair. And we analyze in the work the formal legal proceeding that took place in these areas until the establishment of the settlement in 1983, and the ways legal processes implemented after that in order to show the transformation of the legal situation and the geography. So how the land regime changed, and we show how application of legal tools led to gradual eviction of Palestinian residents and the seizure of their land, and how they used to the establishment of the settlement, and simultaneously to restrict and break up the local space and Palestinian society in the region, but it's very important for us to stress that according to our perspective, we don't think that the Palestinians are just, passive, they struggle, and they have their own agency. So the space is reenacted, or the placemaking, if you want, in an interaction between Israeli, the government, the settlers, the Palestinians, international organizations, and so on. So we now move to the place. As you remember, I showed you before, this is Susia. This is more the area. It's not far away from the green line and the separation barrier. And here is the area. And also interesting, it is located mostly in area C of the occupied territories, but also not far away from area B. Now, because we don't have much time, I'll just go and say a few words about the region. We did also a history of the place. So the area generally is called Shafayata, which is in Arabic high place. And it consists of several small localities in the region. And starting in the 1980s, they were enclosed between the Jewish Susia settlements, Mitzpeh Yair outpost, and also an archaeological site in the region. There is very few research on the region. Most of the research focuses on Jewish and Christian remains, is part of the general historical geography of the region, because Jews are interested mostly in the archaeology of the Jewish site, and some Christian, and also before the establishment of Israel in the 19th century, many Christians arrived, but they were looking for remains of the Bible. So they were not very interested in Islamic or Arabic or Palestinian history. And also through the paradigm of looking at from a Western perspective, many villages, and I will show you later how the people of Susia are living, they did not perceive them as localities or villages. Some of the work that has been done is based on Israelis studying to know your enemy, like intelligence gathering and so on. So you have some information, and some research on spatial developments and the living of what we call the mother villages and settlements of caves, because the residents of Susia are living in caves that they dig. And the area was divided during the Ottoman Mandate and the Jordanian period. We know about the major division. And Israel employed several tools that I will be able to expand, and also maybe Kamal in the Q&A, formal and informal tours, mainly, and here we do the case study of something more general, the declaration of state land. And declaration of state land is not always really state land. It's a lot of time it's Palestinian land, but they cannot prove that they, because the land is not registered, they fail to prove their ownership of the land. Also expropriation of land in order to establish an archaeological site, and allocation of municipal jurisdiction to the Jewish settlement, including the archaeological site, and then planning of the area for settlement. We use some archival work. This is a very important woman, Plia Albeck. She was the head of the civil department of the Ministry of Justice, and she's sometimes called the mother of settlements. She's dead already, but she was a very influential woman. And usually before declaring state land, she would review the situation. And when we're talking about the region, her initial opinion was that it was Palestinian, private Palestinian land. but there was a lot of pressure on her to change her opinion. And then following that, there were 3 declarations in the region of land as being state land. There were many Palestinian barriers, procedural barriers. We have to understand we're talking about some of the people are analphabet, they don't read, they're not connected to the powers. So they were not really aware of the legal proceedings. There is a lot of evidentiary barriers. For example, when the state declares that the land is deemed to be state land, the onus is shifted on the landholder. It's very difficult. You have to bring expert opinions. You have to prove exact registration. You have to use aerial photos that are very expensive and they don't have. And also Israel, if whoever is interested here in transplantation, so legal transplantation, legal transplant, Israel transplanted a rule that it established first in the Green Line within Israel, which is called the 50% rule, which is that a declaration that on agricultural land, the Israeli Supreme Court decided already in the 1960s, before the occupation of the West Bank, that you have to prove that at least 50% of the land was cultivated. Now, in many areas, especially in the mountain, there are boulders, and they cannot succeed in a customary agriculture. They don't cultivate 50%, they cultivate between the boulders. So if you don't prove that 50% of the land that was cultivated, the land is declared state land. And Israel imported or exported, whatever you want, this rule from the Green Line into the occupied Palestinian territories. And this made the life very difficult for Palestinians. And then Israel said, I have the right to transfer the land. So they transferred the land to the Zionist organization, and then the Zionist organization then transfer it to settlers. In addition, and I'm reaching the end of my, in a few more minutes, now I'm talking to the archaeological site, which was declared already by the British in 1944, but they did not expropriate the land. The Palestinians continued to live near the synagogue. There is a synagogue there and an archaeological site, but Israel used the British declaration in order to say, well, this is an archaeological site, so it expropriated the land. And so now we can see the people that were living there, and the establishment, so there were legal proceedings, but already the archaeological site was opened during the appeal. And in fact, only a very small part of the land was excavated. However, the land, the Palestinian land, the village was preserved, but the citizens were expelled, and this was added to the jurisdiction of the settlement. And this is part of, when I talk about land regime, it's including also municipal areas. And later on, 15 years after the actual establishment of the settlement, the jurisdiction of the area of the settlement was declared, and this area is forbidden to Palestinians, which has in the region a few Palestinian land enclaves. On part of them, there is an outpost, a legal outpost that is based, and there was a plan all retroactively. Theoretically, it should have been the opposite side, but the result is the following, and here I will conclude. So you can see, you can see that this is a situation, and you can see that it was almost empty. And here we see the situation in 2018, where the red lines are the areas controlled by the Jews. So there is a huge, and you cannot see it very much, but you can see that this area is built, is transformed. And in the second article, we also shows what happened to the areas that were not officially confiscated, but the fact that the Palestinians cannot reach part of the part. So to conclude, we can see the Palestinians. Here is a photo of one of the Palestinians looking at a photo of their life, and they live. They used to live here, but now they live not far away. This is my last word. They live not far away, and they still fight, and they were digging new caves, and they live in their new caves. So I'll conclude here, and we'll be happy to answer any question. Thank you very much.
Thank you. Thank you, Sandy, and thank you, Kamar, of course, for this most interesting historic and geographic presentation. I think there is at least one red line connecting the three presentations to start a discussion. And may I suggest that we could start thinking of what Marta suggested, that the BRICS countries could, I quote, legalize to have greater international impact. That's more or less verbatim what was on one of the slides. I think this statement of Marta, which might be certainly true, shows how the ideas we have about law and international law have been developed in the West and are not necessarily globally applicable. And this is connected to what Giovanni discussed. BRICS countries are led, everybody knows, by China. And the Chinese approach to the law is that important things are too important to be left to the lawyers. So the BRICS do not go legal precisely to have greater impact, because they play at a very high level, at the top level of political action, choices, and directives. And the law follows. The law is an implementing instrument. As you mentioned, the BRICS countries keep unlegal, at the same time developing legal institutions or legal arrangements for implementing a political vision, which is what socialist nations and communities always do. And this is what China does. So the idea that we should legalize to be stronger is clearly Western. And this is something which is subject to review in the global situation of the 21st century, as Giovanni pointed out. And this is also connected to Sandy's discourse, because when you possess different ideas about the law, you start much before setting the rules, much before that, according to your different vision of law, you define the subjects of law differently, or the objects of law differently. Is BRICS a subject of law? Is Jerusalem an object of international law? What is the object? So first you define what is an object, then rules might be discussed, of course, might be different, but the core, the deep roots of the differences in clashes of normative orders is in the definition normally. Very often, not necessarily so, but very often. So this is certainly interesting. And another interesting remark is that you can debate on different ideas, but ideas boil down to hard things when you discuss about land, and this is what makes Sandy's discourse on legal geography interesting, because you can have lofty discussions, but when it comes to land and to borders, you have hard things you can touch. Is this mine? Is this yours? And at the end of the day, there is a famous case of the Israeli Supreme Court endorsing the construction of the wall. We all know that. But in one of the cases, there is a remark that the wall is necessary for national interest, for the protection of national security, blah, blah, blah. But still, the court had to recognize that there was some violation of property law. And whether this has an immediate impact or not on that particular piece of land, the statement made by the Israeli Supreme Court stating that somehow the wall violated the property law of Israel might have some significant impact in the long term in the political negotiations or discussions or conflict between the two relevant entities. So a significant medium to low significance decision on land law might have a very significant political impact in the long term. Legal issues can be politicized and political issues can be legalized, of course. So in this back and forth negotiation, there is a lot of room to introduce other elements of evaluation coming from other normative systems, from other political consideration, making the journey complex from the law in the books to the law in action. And in this journey, you have a lot of things playing their game. And of course, different notions of what the law is and how it should work increase this complexity. So I leave it with that. I would love to read the 3 papers you are working on. I'm talking to the 4 speakers. I'm really eager to read them whenever they're ready. And so now I leave the floor for the discussion.
So I think maybe we should see if there are any questions from the audience, no, first,
Yeah,
or whatever.
there should be any. We have an audience of about 10 to 12 persons. We are waiting for questions from the audience. Otherwise, we can start discussing among the panel members. Oh, Ornella raised her hand. Ornella, we don't see you. Yes, we do.
Yes, can you see me now? Yes, so I wanted to ask Marta, since you talk about legal network, definition of the BRICS, what are the tools that are used for intra-BRICS cooperation? How does it work?
Okay, thank you very much for your question. Actually, cooperation intra-BRICS is pretty much articulated in the sense that we can see two main levels. We have the head of the states level, so the coordination that occurs during the summits, and here we've got an exchange of views and talks about what is of international concern for these states. Also, the summits are actually the result of the heavy preparatory work that occurs before the summit. And this is the moment actually where the BRICS try to talk to the rest of the world, actually, to non-BRICS countries. This is where they release declarations where they state their ambitions, their vision of the world. The second level is the interministerial level. So we've got these ministries meetings on key issues that may be health, energy, sustainability. And so they try to coordinate in such key issues. But actually, many other types of networks are in place. There are think tanks, networks, research projects that aim at involving many layers of the civil society. So also students, academics, citizens, organizations, local entities. There's a kind of a very bottom-up response that involves also social entities.
Okay, thank you, Marta.
Thank you very much.
Thank you.
Livio, you want to ask a question, of course.
Yes, thank you very much. And let me say first that I really appreciate all your presentation, which are really interesting and kind of new topics for me, especially the relationship between land and law, which is very interesting. But to be honest, I have a question related to the presentation of Giovanni Barbieri and Marta Bono, because, to be honest, I'm always, we know each other in real life, and I always agree with their idea, to be honest. But this time, I was a little bit hit by the idea of effectiveness of international law. I mean, to Giovanni, don't you think that finally international law remains a representation of a strength relationship between international subjects? And this is something that I can always detect in the BRICS, because probably the flexibility that characterize BRICS make it less effectiveness. I mean, I don't know.
Shall I reply right now or wait? Okay. If I'm not wrong, there was an international public law scholar. If I'm not wrong, it was Cassese that defined international public law as a sinking ship. In my view, the point is that international public law is effective until every state that make the international community agree on the effectiveness of international public law, even because you don't have a superior body to state sovereignty that can judge states. A tentative effort was made with International Criminal Court, for instance, which was supposed to prosecute state officials who for grave breaches of international humanitarian law. But by the way, I think that I talk about the link between political order and legal order, and I think that this is this could be referred both to the presentation of Sandy Kwamar and Marta. Why I say this? I say this because in the case of Marta, for instance, Marta is wondering whether or not BRICS need a legal definition. The point is that what Marta calls, in my view, the dark side of BRICS is a dark side for us, but perhaps it's not a dark side for BRICS countries and officials. And this is due to a different perspective on law that Western people take in respect with Eastern population, or in the case cited by Alexandre, Sandy, and Kwamar, indigenous people. For instance, the Chinese approach to international relations and international law is deeply affected by the Tiansha doctrine. That is a complex of philosophical and political ideas and principles that departs largely from Western liberal and democratic principles on which were built all the political and legal tradition of Western countries. And it encompasses as well the concept and understanding of democracy. And in the case of indigenous people, like the case of the Siusia region, but it can be extended, for instance, to the rights of indigenous people of South America and Latin America, you can see and you can experience the clash between a rigid and strict vision of law based on property rights, on rights based on settlement traditions, and so on, and the rights conceived by indigenous people based on tradition, based on culture, based on heritage. And this situation, you ask, is international public law effective in addressing all these problems? No, it's absolutely not effective in addressing all these problems. I think that the answer to this pathology, because this is a real pathology, is to open up our minds and the way how we study and we address these issues, and to adopt a pluralist approach. It means to be really pluralist in each field of study. It can be law studies, it can be political studies, it can be economic studies, briefly of the social science field. And to be really pluralist in acquiring all the instances that comes from different political and philosophical traditions that actually makes the international community and would make the international community really hanging together. Okay, so this is my view. Perhaps it's a little bit dispersive, okay, or confusing, but this is my belief.
Can I jump in?
Yes, of course.
Okay, so I want to continue maybe the line of Giovanni, in the sense that I think that we have to make a clear distinction between the effectiveness of law and whether it's dark or not. There are two very separate issues. Law can be very effective and very dark. I think what we show in our work, and I will say also a few words about the international law, but what we show in our work is that the law is extremely effective in the project of Judaization of the land in occupied territory. It's part of the tools of the occupier. And in a sense, when we look at the international law, so I think it's a two-edged sword. On one side, the whole system of the Israeli occupation in the West Bank and the whole charade of a temporary occupation, and the fact that Israel is being able to, according to my view, to establish a system that is very similar to apartheid system without paying the price, is because of the legitimation that the international law gives to it under the idea of a temporary occupation that is going on for such a long time. On the other hand, it also puts limits. So the way some limits, and Ignacio, you mentioned the barrier or the wall, and the wall, you know, the Israeli court had to face the fact that there was an opinion of the International Court of Justice, and the Israeli Supreme Court wanted to enter into dialogue to preempt and to show that it is doing something, and it moved some parts of the barrier, although still in the occupied territory and still not accepting it. So the way I see it is, I think that the law generally and international law also particularly is an arena of struggle, but it's an arena that is very skewed in favor of the powerful, of course, like all law. I'm come from a critical legal perspective. I think all law works for the powerful, but sometimes the weak parties can use it against the powerful. So it's not, and so this is the view I see it, and also I answer here the part of the comment of Ignacio, that and I think that in order to look at these things, you have to understand both the formal making of the law, and we take in our work, we take very seriously the doctrines, the precedents, but we also look at it from the outside, because we understand that it is a tool also. And and we show, for example, the work that in each junction, almost the Israeli courts select the most detrimental interpretation to the law to the Palestinian. And but in order to be able to do that, you have to understand very deeply how law is deployed. So I will stop here. Maybe Kamal, you want to add something? No? Okay, so.
May I just make a small comment about what we have just discussed? And then I've got a question for Alexander as well. So just a little comment on the flexibility issue and the fact that and how it impacts on global governance. This is what I've stated because I have looked at the impact that the BRICS have in the international organizations. And sometimes this flexibility, this high level of flexibility hinders the group from having a cohesive and coherent position. So to act as a coherent group. And it comes to my mind, for instance, in 2012, when there was a discussion within the World Bank about the nominee of the president that has traditionally been American. And among the reform asked by the BRICS, so there was the reform of the quota sharing, but also the way the heads of these institutions are nominated to be more transparent and democratic and so on. So they could have acted cohesively to support, if I remember correctly, was a Nigerian or a Colombian nominee. So they could have changed the face of the organization, but they couldn't, and they paved the way to the American nominee. So that's why sometimes flexibility is good, and it proved to be a winning choice when it comes to the internal coordination and cooperation, but sometimes it hinders the group to achieve its aims externally, so in the global governance. If you may discuss about it, I don't know, this was my impression. And then I was wondering, I'm not, of course, an expert about property law, but I was wondering how is that possible that the Palestinians who have lived for years and years on those territories can be deprived of their land and have no legal means to claim them back. I mean, there's no legal way to do that at all.
It would be interesting to listen to Kamar's comments on that one.
Kamal, do you want to take?
Yes. Yes, they do have legal means to resist legally declarations and other formal legal tools, but it's not big successes. They can do it on a micro level, but still there's the interpretation of the laws, the Ottoman laws, that contradicts the interpretation of the British or the Ottoman of the local laws. But still it's much more difficult with the Israeli legal system, but still there are some successes or some ways to resist legally with legal tools this interpretation. But still we're not talking about the macro level, because you see about more than 100 settlements in the occupied territories was built on what is called state land, according to the interpretation of the laws by Israel. But still, there are some successes here and there to just to prove that it's a private land, and still Israel just exploited these local laws. And the fact that most of the lands are not registered in the occupied territories, so people just can't prove 100% that it's theirs. But though they are more than years are there.
Just to add, this is, I think, part of the legitimation, because because at least the Palestinians have a chance to win. Okay, it's very small, but they have a chance. And Kamar is representing Palestinians in tribunals and in court and fighting. And you ask them, why do you do that? And say, because we don't have. So sometimes we win, and sometimes we win in the shadow of law, having bargaining with the military or so on. So there is this power that it's not pure dispossession. There is a game, and sometimes in order for the game to work, you have some time to have the chance to win. Otherwise, it will not work. It will, you can dispossess completely. But what we do in the work is we look at what's going on the general space. So sometimes they win, but on the general, so they win, let's say, a few dunums here, a few dunums there, but the project of settlement continue, and they have small patches of land left in between. And if you want, Marta, I have written an article many years ago on the situation in Israel, explaining the doctrine that was later, it's the same system essentially. And it's because I don't want, I think we're over time, but I would say a few words. Just Israel is using the Ottoman land code as a basis. So it's very powerful, saying it's not us, it's the Ottoman. And it changed its interpretation. And because the land is not registered, you have rules that layers of the Ottomans, and then the British mandate, and then the Jordanian, and then the Israeli military and the international. And you have to go over all these barriers, legal barriers, and sometimes you succeed. But if you look at the percentage of land left within the Palestinian, it's very small. So that is what is so sophisticated in this case, because it's not like, okay, we take all the land of Palestinian and that's it. No, you will go and you fight, and then you win a little bit, but the expansion is succeeding, the Jewish expansion.
Thank you very much. I would love to
So
read
send me a mail and I will send you some stuff.
Yeah.
Okay, I am on the program.
If I may add a comment, the fact that occasionally you win a case is precisely what gives legitimacy to the entire system. So you give something to take the most, and it's part of every uneven balance relation dynamic, that whoever is stronger must concede something to keep the game going. Otherwise, it will
Exactly.
keep going. And so how much you give is related to the price to the political price you would pay if you didn't give anything at all. And so the negotiation is never always legal, and neither it is non-legal. You must know the law. You must be very good at that. You must be perfect in the court. Plus, you need to understand the context, which is pretty much what happens in many non-Western legal environments, where the law is there, is important, must be understood, practiced, but at the same time you have a lot of context sipping in the segment which is between the book and the action, so to speak. Well, do we have any? No. Well, it seems we have reached a point of equilibrium or satisfaction with our session. I certainly was very happy with what I heard this morning, very inspiring. I thank all the distinguished speakers. I wish I could read their works as soon as they're ready. And this is Juris Diversitas. We do networking, we get friends, we learn from one another. So let's keep this dynamics going on, online or personally, as soon as possible, inshallah. And well, let me thank you all again and to invite you to be present at the AGM this afternoon 4 p.m. Lausanne time. Thank you all, and bye-bye.
Bye-bye. Thank you.
Thank you.
Thank you very much.
Thank you very
Thank
much.
you very much.
Bye.